How's it going, everybody? Welcome back to 2A News Now. My name is Troy, and I really appreciate you taking your time tuning into my video. A couple of days ago, I made a video about if you travel to California, your Second Amendment rights stop at the state line. A judge just ruled in a Massachusetts case that that's BS, that your Second Amendment rights don't stop at the state line. Since the Bruen decision has been handed down by the Supreme Court last year, we're starting to see lower courts around the country start to take the Second Amendment a little bit more seriously. While we've still seen some egregiously awful readings of Bruen, over the past 12 months, we've also seen some major success, including one case out of Massachusetts that addresses the fact that in many states, your right to keep and bear arms stops at the state line. A Massachusetts judge recently concluded that the state's prohibition on non-residents bearing arms for self-defense without first obtaining a temporary license to carry is a violation of their Second Amendment rights. It's a stunning development in a state where lawmakers are currently trying to obliterate the Second Amendment rights of gun owners inside the borders as well. An individual only loses a constitutional right if he or she commits an offense or is or has been engaged in certain behavior that is covered by 18 U.S.C. Section 922. Judge Coffey wrote in the case, Commonwealth of Massachusetts versus Dean F. Donnell. He doesn't lose that right just simply traveling to an adjoining state, whose statute mandates that residents of that state obtain a license prior to exercising their constitutional right. To hold otherwise would inexplicably treat Second Amendment rights differently than other individual held rights. Therefore, the court finds GL 269, Section 10A, is unconstitutional as applied to this particularly situated defendant and allows the motion to dismiss on that ground. The ruling could have significant implications to determining the scope of the right to carry a firearm in public. It is one of the first legal decisions to address gun carry rights across the state lines since the Supreme Court recognized a general public carry right in New York State Rifle and Pistol Association versus Bruen last June. It could fuel gun rights advocates' push for a right to travel in all 50 states with firearms in public, also known as national reciprocity. The defendant in this case, his name is Dean Donnell. He is a legal resident of New Hampshire. New Hampshire is a permitless gun carry state, meaning anyone 18 years of age or older who can legally possess a firearm can carry it in public openly or concealed. It also issues carry permits to residents for reciprocity purposes. However, Massachusetts does not honor New Hampshire permits. Judge Coffey's order does not specify whether or not Mr. Donnell had a valid New Hampshire permit, only that he was in compliance with his own state's laws on the possession of the firearm. When Massachusetts charged him, the law under which he was charged, DL 269, Section 2A, creates a mandatory minimum sentence of 18 months in prison of anyone convicted of possessing a firearm in public without a license. Judge Coffey wrote that Mr. Donnell's conduct was clearly covered by the Second Amendment, therefore under the standard of review under Bruen. He said the government of Massachusetts needed to show a historical tradition relating to disparate treating of non-residents to uphold the law. And of course the state couldn't do that. Instead, attorneys argued that previous decisions had upheld the state's authority to require a permit to carry, and that the non-resident permit process complied with the Bruen decision. Judge Coffey disagreed, pointing out the resident and non-resident permits are substantively different from each other. Judge Coffey went on to say, prior to the Bruen decision, Massachusetts treated the carrying of a firearm as a privilege, while it allowed for non-residents to apply to obtain a license for that privilege. Non-residents were not treated the same as residents. Residents of Massachusetts obtaining a license were granted the license for 5 years. On the other hand, a temporary non-resident license was only valid for 1 year. As a result, Judge Coffey held that the state failed to meet its burden in proving that Mr. Donnell's conduct was not constitutionally protected and warranted a felony charge. This court can think of no other constitutional right when a person loses simply by traveling beyond his own home state's border into another state, continuing to exercise that right, and instantaneously becomes a felon, subject to mandatory minimum sentence of incarceration. Judge Coffey's decision isn't an immediate game changer than anyone other than Dean Donnell. But it's very good news for gun owners across the country, and a sign that the courts are going to have to take this issue seriously. Why should anyone visiting places like California or New York be deprived of their Second Amendment rights when they cross the state line? Or maybe a better question to ask is, why authorities in these states think they can get away with violating the constitutional rights of non-residents? Judge Coffey made the right decision. He applied the Bruins decision to Massachusetts unconstitutional law, and Massachusetts unconstitutional law for non-residents lost. There needs to be more judges in place like Judge Coffey to stop this madness of states trying to infringe on our Second Amendment rights. I would really like to hear your thoughts on Judge Coffey's decision in the comments section down below. And as always, I appreciate everybody's support with the channel. You guys are always crushing it by liking, sharing, and subscribing, and hitting those post notifications. And I invite everybody back to see my next video.